This case starts like a routine plea deal, but don't be fooled. What looks like a second chance quickly spirals into a high-stakes courtroom test of honesty, responsibility, and consequences. We've got a defendant already convicted of a serious felony asking for leniency, and a judge who's not here to play games. The real question is, will this second chance hold, or will one mistake send everything crashing down? Stay locked in, because what unfolds next is a perfect example of how fast probation can turn into prison time.
23 CR 8093, State of Texas versus Monica Wade. Ms. Zach.
Yes, ma'am.
Mr. John, can
Yes,
you
Your
announce for the record?
Zach Dunn for the state, Your Honor.
All right. We are back on the record in the state of Texas versus Monica Wade. Ms. Wade, I'm going to give you a choice. I read the report. I know there are issues. I will either sentence you to prison or either I will give you probation. I will sentence you to prison for 3 years or either I give you probation for 8. Which do you prefer?
I would like to.
All right. Court is finding you.
Right here, the court confirms something critical. This is a felon in possession of a firearm case, which is already a serious offense under Texas law. The plea agreement includes 5 years prison time, but it's being held back, meaning the judge is considering probation instead. That's huge. Probation isn't freedom, it's a strict legal contract. One violation, even a small one, can bring that entire prison sentence crashing down instantly. So when the judge asks about her behavior and background, this isn't casual conversation. This is the court deciding whether she's trustworthy enough to stay out of prison. What would you do in this situation? Take the risk or lock in the sentence?
Guilty. The court has sentenced you to 5 years in the prison, suspended and probated for 8 years. There's a $1,500 fine that will be probated. And Adriana, if you could tell me what the court cost in this will be, it's a third-degree felony. Taking into consideration 2023 CR 9034, there's $60 restitution to SAPD for testing, and 2023 CR 9034, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, field visits 1 time per month for 3 months, and then at the probation's discretion.
This moment is powerful land strategic. The defendant is appealing to the judge's sense of empathy, bringing up personal tragedy, family responsibilities, and the desire to change. And in court, that matters, but only to a point. Judges hear stories like this every day, so the real question becomes, do the actions match the words? Because while her story is emotional, the court is focused on behavior, compliance, and risk. Sympathy might open the door, but consistency is what keeps it open. Do you think her explanation is genuine, or is this just a last attempt to avoid prison?
Thereafter, 200 hours of community service restitution, MIC evaluation, or some type of trauma counseling, parenting classes. Once you've completed the parenting classes, your community service hours will be deemed satisfied. Probation, is there anything else she needs?
No.
Is there anything else you need from the court?
No.
And what is the cost of court costs? All right, the court cost in this case is going to be $325. If that is given to you in installments, will you be able to pay it?
Yes.
All right. Defense, there's something you wanted to say?
Judge, she did participate in complete parenting course.
All right. Is Child Protective Services involved in this case?
No, ma'am.
All right. This was completed in January 2024.
Yes.
That's been over a year. So you're going to have to redo it. Do you understand?
No, that was just.
Okay. It says date of course of completion, January. Oh, 24. Oh, I keep forgetting we're in 2024. Thank you for speaking up. All right. Just turn that into probation. It'll be acceptable.
Okay, thank you.
And just like that, the judge makes a huge call. Instead of sending her straight to prison, the court suspends the 5-year sentence and grants 8 years of probation. That's not leniency. That's a long-term test. 8 years means constant monitoring, strict conditions, and 0 room for error. Notice the detailed requirements: drug testing, employment proof, restricted job roles, community service, counseling. This is a full lifestyle overhaul. The judge is essentially saying, you get your chance, but I'm watching everything. The real challenge starts now. Because probation isn't about avoiding jail, it's about proving you deserve to stay out.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
We're off the record. You can go take your break. All right. In this court, to be successful on probation, communication is key. If you feel like there's an issue, let probation know. If you feel as though they're not addressing it, you can come back to the court. Do you understand?
Yes, ma'am.
All right, good luck to you.
All right, thank you.
Thank
Thank
you. You're welcome. All right. Court is calling 2000. You need to slide over this way. Court is calling 2023
You're on this side, sir.
CR 8093, State of Texas versus Monica T. Wade. Can I have parties announced for the record for the state?
Andrew Harris Sidman.
Denny Callahan defense.
And are you Miss Wade?
Yes.
Did you review the document entitled Motion to Remote Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Monica T. Wade who was placed on community supervision in 2023 CR 8093 for the offense of felon in possession of a firearm on January 25th, 2024 for a term of 8 years? Is that you?
Yes.
State?
Violated condition number 1, Your Honor. In condition number 11. Your Honor.
All right, according to condition number 11, the state is alleging that on or about the 20th day of May 2024 in Bexar County, Texas, the defendant, Monica T. Wade, did then and there fail to report to the supervision officer on the next working day after being released from jail for a new arrest in violation of condition number 11. How do you plead to that? True or not true?
True.
State, any other violations?
Waive and abandon the remaining violations, Your Honor.
Any objections?
No objection.
Did you understand by pleading true to violation of condition number 11, the court could find it true, grant the motion, and sentence you up to 5 years in prison
Yes, ma'am.
and up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 11?
Yes, ma'am.
Court is finding violation of condition number 11 true. Is there a proposed agreement?
Yes, Your Honor, to impose jail sanction, but otherwise continue on supervision.
Your Honor, we ask that the time that she has already served be considered as JSAT on the jail sanctions, that the court is going to go that direction.
All right, so why should she be continued? What has she done on probation? She's been on probation since January of 2024. What has she done? Probation?
Hi, Judge. Since January of 2024, she's submitted 3 negative drug tests with the most recent of 6/17/2024. She has completed her mental health evaluation. Her parenting class is complete as well. And that you waived her community service hours with that completion of the parenting class. There's been a total credit of $150 for her fees and fines. And that's it, Judge.
All right, so she's pled to having been arrested and not report to probation after her arrest. What has she been arrested for?
May I address the court?
Yes.
Felon in possession. That case is still pre-indictment pending. It's in the
And here's where everything starts to fall apart. The defendant admits on record that she failed to report to probation after being arrested again. That's a direct violation of her conditions. In legal terms, this is serious. When you're on probation, reporting isn't optional, it's mandatory, immediate, and non-negotiable. Now, the judge is laser-focused, because this isn't just about paperwork, it's about accountability. The moment she says true, she's essentially handing the court the power to revoke her probation entirely. One mistake, that's all it takes. So now the question is, does the judge believe this was confusion? or avoidance.
Dependent of the resolution of this case.
All right, so she's on probation for felon in possession of a firearm. I know the state has not proceeded on the violation that you just mentioned, the felon in possession of a firearm. But my concern is that she was arrested and she didn't report to probation after her arrest. So does she want to explain to the court why she did not do that?
Yes,
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Monica Wade.
All right, why didn't you report?
When I initially got out of jail, I was not informed to go to report to the office.
I'm
but
sorry, you was not?
informed to go report to my probation. But I contacted my attorney because my concern was I going to be issued an MTR immediately since they gave me?
No, but it's in your conditions that when you're arrested, you need to contact probation and let them know. That's one of your conditions. Am I wrong in that?
No.
Okay, so you knew you were supposed to report after an arrest.
Okay, so then when I contacted the attorney, I asked him, I said, is there an MTR that was issued? Because if that was the case, I would like to see if I could do a satellite walkthrough. That way we have to go through the whole process of sitting in jail and doing all this, all that.
Well, no, let's go back to the fact that you knew, because you had conditions of probation, that when you're arrested, and you just told me you knew when you're arrested and you're released, you have to report to probation. So what I'm hearing from you, and if I'm wrong, correct me.
Okay.
What I'm hearing from you is the reason why you didn't want to report to probation is because you didn't want to get arrested and have to wait at the jail. You wanted to do the easy way and see if you could do satellite. Am I correct in my interpretation?
And no, ma'am, when
All
I
right.
did get the rules and the regulations on, I did not know until after the fact, when I was contacting my attorney about this MTR, is when I got my probation paperwork and I read it, and it did state that I had to report after. I was not aware of it before.
No, but they go over conditions with you, every condition.
I must have not heard it. I just didn't. So that's why I didn't go report immediately, but I had been reporting with no problem. I haven't given them any issues. I'm on top of the classes. I'm on top of the money. I'm on top of.
I mean, I understand what you're saying, but you know what you're not on top of? And I don't know that the allegations, the state has waived and abandoned that in the allegations, but what you're not on top of is you were arrested for another offense.
Yes, ma'am.
And the number one thing when you're on probation is don't commit any new offenses, allegedly.
Correct.
And I'm not going to get into that new offense because the state is not proceeding on that. But you have to report.
Right.
And I'm inclined to follow your agreement, but I'm not inclined to have you walk out of here without doing your jail time. You understand?
Yes, ma'am.
All right. Is there anything else you wish to say?
No, ma'am.
All right. And what jail time are you all asking for?
The credit that she already has is how much? 25.
So, well, no, how much time is the state asking for her as a condition? I'm not giving you credit for the 25 days. You're going to go into custody today. All right, the court will deny the motion. Alternate amend conditions to include 25 days in the Bexar County Jail. Upon your release, you need to report to probation.
Yeah.
And state, you need to figure out what is going to be happening with that new case. How much time do y'all need to determine what you all want to do with that case or what's going to happen with it?
Unclear, Your Honor.
All right, and Mr. Callahan, are you on the new case?
Yes, Your Honor.
All right, Ms. Ferguson, her new case, let's set that in 60 days. And if you could give her a reset for that. Probation, is there anything else?
This case is a perfect example of how probation works in the real world. The judge initially gave the defendant a major opportunity avoiding prison with an 8-tier probation sentence. But probation comes with strict rules, and failing to report after an arrest is a serious violation. Even though the court didn't revoke probation, the judge imposed 25 days in jail as a sanction, making it clear that noncompliance has consequences. The bigger issue, a new pending charge that could completely change her future. This case highlights a powerful lesson. Second chances exist, but they come with zero tolerance for mistakes. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.